Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about an issue that comes up in appeals called the necessity of a final order. I'll have more on that in just a moment. So one of the things that we have to have when we write an appeal is something to appeal from. Usually that's a ruling by the court, and the ruling by the court, in order for it to be appealable, it has to dispose of all the issues between all the parties. So several years ago, we were involved in a case involving an insurance claim in a homeowner's suit. And the homeowner had sued multiple people. He'd sued the contractor who did the bad work, and he sued that contractor's insurance. He sued an architect. He sued the concrete company, and he sued his own insurance. And after all of the cases were dismissed or settled as to some of these other parties, then the issue came up as to the claim with regard to the insurer. And then it took literally 10 years to get to that point because of the way basically the pace of the case went. So it wasn't until we had basically what happened, the early on, the court dismissed the claim, or on summary judgment, issued a summary judgment that said the homeowner had no claim against his insurer. Then he went and litigated with all of these other parties and eventually got to the point where all of those claims were either settled or dismissed. So the only thing that was left was the summary judgment that had been issued against him by the trial court and on behalf of the insurance company. So about 6 years after that order was entered, he appealed it. And the reason that it took 6 years to get to that appeal is because until that time, all of the issues against all of the parties in the lawsuit had not been finally decided. But now they had, and the order can, and the judgment on summary judgment can go up to the appeals court, and ultimately the appeals court reversed it, and it worked out quite well for the homeowner. But there had to be a final order in order for it to be appealed, or in this case, a final judgment. And that's for a very practical reason. One of which is that you don't want to have piecemeal appeals. In other words, you don't want to appeal this piece of the case and wait for a decision on that and then come back and try all these other parts of the case, because as time marches on, people's memories do not get better. In fact, they almost always get worse. And as a result of that, you don't want to have a situation where somebody is coming in and testifying as to what they remembered from 6 years ago if you can have them testify about what they remembered just a year ago. One thing that often comes up, particularly where there are multiple claims, is the court will dismiss one of the claims. And the issue will be, that's very central to the relief that we wanted. We want to appeal that because you've dismissed it. Well, if there are other counts in the complaint, that can't happen unless the court authorizes an interlocutory appeal, which basically means while the case is going on, you're appealing this one order. And that's basically a discretionary act of the judge. And what the judge is deciding is whether or not waiting for that judgment is going to unnecessarily delay the resolution of the claims. Interlocutory appeals are fairly rare. Also, when someone files a motion to dismiss and loses, they are aggrieved, but you can't appeal the dismissal or the failure to grant a dismissal. You can't appeal the failure to get summary judgment. The only thing you can, as with everything in the law, there are sometimes some exceptions to all of these things. And one of those exceptions is where you have a situation where the issue being appealed is collateral to the main issue in the case, but nevertheless might wind up being dispositive of the rights of the parties. And I'll give you a good example. Florida and Alabama have concealed carry laws that allows a person who uses deadly force to request an immunity hearing. And this immunity hearing is designed to determine whether or not they even have to stand trial. So if the prosecutor charges somebody with manslaughter, for example, as a result of an asserted self-defense shooting, that party has the right to have this immunity hearing. And if that immunity hearing goes against them, then they have to stand trial. Well, in some situations, particularly in federal court, if the issue is an immunity, you can use what's called the collateral order doctrine to appeal it. Double jeopardy is a good example of that. Let's say you had a situation where someone stole a car and first they were prosecuted for joyriding, and then later on somebody wanted to prosecute them for grand theft auto. Well, again, the issue here is the second one is probably foreclosed by the first prosecution. So someone could bring a motion to dismiss based on double jeopardy. If that motion to dismiss is denied, then in the federal courts, at any rate, you could take that up on appeal through the collateral order doctrine. I don't know that you can do that always in state courts, but the purpose behind an immunity statute, the purpose of those doctrines is to prevent you from having to go through the time and expense of trial. So if you don't get the benefit of the immunity or the double jeopardy clause, then you should have a right of appeal at that point. And you do in federal courts, but oftentimes in state courts they say, well, we'll work it out at the end. And of course, by then you've expended thousands of dollars paying a lawyer to defend you when you probably didn't need to, if indeed the immunity was a valid concern. Another issue that sometimes comes up in context of final orders is class certification, where someone files a class action lawsuit, for example, against Walmart because they have bad garbage bags or they have bad plastic bags to carry your groceries home in. Somebody files a class action lawsuit on that, and the trial court certifies the class as against Walmart. Well, Walmart has a right to request an interlocutory appeal. This is not an appeal of right. This is an appeal that is based on the discretion of the appellate court. And if the appeal goes up to the appellate court and the appellate court decides to take the appeal, then the issue of class certification gets appealed before anything else happens in the case. On the other hand, if it goes up to the appellate court and the appellate court says, no, we'll deal with this later, then it goes back and progresses and the class certification is done and the class is tried. And if there is a judgment against the defendant, then they can appeal both the class action certification as well as any errors that they claim were made in the trial on the final appeal through the final order doctrine. Those are some of the issues that come up in what's called this final appeal or final order doctrine. You can't appeal from part of the case under normal circumstances. You have to wait until the case is finally resolved and then take an appeal. If you have any questions, please leave them in the comments down below. Otherwise, thank you very much for watching and have a terrific day.